For example, Young Thug asked Atlanta Police Department Detective Belknap, "Do you know there are videos of countless performers or athletes where they are promoting their trade?" The state objected to this question. So we have another response from the state going in on these vague questions that Brian Steele, aka Jeffrey Williams, aka Young Thug, had an issue with. We're going to go ahead and get right into it and see what the state is saying in their response to this. We got the state of Georgia versus Young Thug, aka Jeffrey Williams. And this is a letter to Judge Whitaker. State's response to defendant's motion in opposition for correct ruling on vague questions. Here's the introduction. On June 10th, Young Thug moved this court to vacate correct or proper rulings on the state objections precluding cross-examination with vague questions. What is the note? On July 10th, defendant Young Thug filed an amended motion. Defendant Young Thug's motion addresses multiple separate evidentiary rulings. The motion addresses paragraphs 10 regarding state objections to vague questions. All right. Williams or Young Thug does not include a request specific relief or provide authority to substantiate his request. Instead, Williams cryptically asserts that somehow his right to effective cross-examination has been curtailed. The trial court correctly sustained the state's objections to Young Thug's vague questions and has not impeded Young Thug's right to cross-examination. Young Thug's motion should be denied. Argument and citation of authority. At the outset, Young Thug never provides authority that inquiring into vagaries. What? Oh, I'm definitely using that word. Have y'all heard this word before? Vagaries. I'm going to start telling people, stop using vagaries. At the outset, Young Thug never provides authority that inquiry into vagaries classifies as a specific mode of cross-examination imparted by constitutional requirement. See Johnson versus State. Unlike many other modes of impeachment, attacks on witness bias are constitutionally guaranteed. Even grounds that can we get the district attorney's office just one paralegal? What are we doing? Even grounds that are continuously protected, however, may be subject to judicial controls. Lucas versus State, the right to inquire into partiality and bias, however, it's not without limits. The Fifth Circuit has made it clear that ambiguous questions are not constitutionally protected and subject to exclusion by trial courts pursuant of the rules of evidence. I don't know about this one now. This one seems a little bit wild. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective to determine the truth, avoid wasting time, and protect witnesses from harassment and undue embarrassment. The rule permits courts to preclude questions that obscure truth because they are ambiguous, confusing, misleading, argumentative, compound, or assume facts not in evidence. I mean, so that sounds like a vagary to me. I love that word. Young Thug's motion attempts to constitutionalize an areas of cross-examination that is not so protected. So they're saying there's a gray area, even assuming, okay, we read this in the last one, so we're going to move forward. Young Thug's Sixth Amendment right to effective cross-examination is not infringed by disallowing vague questions. The court has correctly sustained state's objections to defendant Young Thug's vague questions because such questions are impediment to ascertain of the truth. Holds to that jury proceedings shall be conducted to the extent practicable so as to prevent inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof of asking questions in the hearing of the jury. Okay, and then they cite here, we can see Carlson and Carlson. We won't look at that. Courts are, moreover, mandated to exercise reasonable control over the mode and order of interrogating witnesses and presenting of evidence in order to make interrogation and presentation effective for the ascertainment of the truth. Defendant Young Thug argues that the court's sustainment of objections for vague questions have curtailed defendant Young Thug's Sixth Amendment constitutional rights, but cites no legal authority for that proposition. I mean, I guess the only authority he needs is that he should be able to ask the question. Is that what they're saying? He argues that the court's sustainment of objections for vague questions have curtailed. We'll keep reading. Case law explains that the Sixth Amendment provides two types of protections for a criminal defendant: the right physically to face those who testify against him, and the right to conduct cross-examination. State v. Burns. However, the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. All right, let's skip ahead a little bit. Vague questions are improper. Defendant Williams' Young Thug's assertion that this court has incorrectly sustained objections to vague questions is incorrect. The 11th Circuit had held that a question or phrase is ambiguous as a matter of law when it is not a phrase with a meaning about which men of ordinary intelligence could agree. Okay. I mean, saying this, I don't know. Who determines that though? I guess the judge does. Nor one which can be used with mutual understanding by a questioner and answerer, unless if were defined at the time it was sought and offered as testimony. Ambiguous, i.e. vague questions, are impediment, to the assertion of the truth, because such questions left undefined by the questioner prohibit mutual understanding to the meaning behind any answer by the witness. Repetitively proposed vague questions by Young Thug's voice cluttered confusion on the jury. We're learning a lot of new words today. Whereas unambiguous proper questions provide the jury with concise clarity of the facts and better equips them to ascertain the truth. Okay, so we're going to go through there. That's fine. We're going to go through the conclusion at the end here in a second. Let's just read this last paragraph. The prior objections, the state has lodged and inadequately phrased vague questions asked of the witness by defendant Young Thug have been correctly sustained by this court to facilitate ascertainment of the truth. For example, Young Thug asked Atlanta Police Department Detective Belknap, "Do you know there are videos of countless performers or athletes where they are promoting their trade?" The state objected to this question because it was vague. That's a vague question. So should he have asked, "Hey, have you ever seen Sierra or other artists perform?" How is this a vague question? He asked, "Do you know there are videos of countless performers or athletes where they are promoting their trade?" Okay. The state objected to this question because it was they are being petty, man. This is, come on. The question was ambiguous because it is unclear what videos, which performers, and what trade the question referenced. Okay, I could possibly see the trade. Because if we're going to talk about WAP by Cardi B and Meg Thee Stallion, then I mean, maybe you might be wondering what the trade is there. I'm gonna leave that one alone. So maybe I'll give them half a point on this one. But I mean, come on. If you're an athlete or a performer, your trade is performing or being an athlete. It's not that complicated or vague. Wow. Court properly sustained this objection. Shout out to Glanville. Of course it was proper. On the grounds under its inerrant authority under 24-6 611. Young Thug's assertion that his Sixth Amendment right have been curtailed by the court's sustain of the state's objections to vague questions is invalid and unsustainable. There is no constitutional or statutory right to ask irrelevant, vague, and ambiguous questions during cross-examination. This court's prior evidentiary rulings on this matter have been in accord with the Georgia and federal constitution and rules of evidence. Young Thug's motion should therefore be denied. Adrian Love. I hit the wrong sound effect. So y'all let me know what you think in the comments and in the chat. Is this petty? Does the state have a point? Does Brian Steele need to back off? I'm gonna let it go at this point. It's up to y'all.